Welcome to Mirror, Mirror on the Wall, which professor knows it all? I am your host, Cornel Stevens. And please welcome our lovely contestants, Professor Curcio, Professor Washington, and Dean Timmons, the torts teacher. Now, we have been talking about discovery, and more precisely, we have been talking about the limits to discovery and work product protection. Now, work product protection is governed by two essential rules. Rule 26b3 governs tangible work product, and the case Hickman v. Taylor governs intangible work product. Now, the question is, just what do those doctrines and rules say about work product protection? And that is what our lovely contestants are here to answer for us today. We have two exciting rounds for you. We have the first round, and then we have the final round, which will involve just two of our contestants, so one person will be eliminated after this first round. Now, here are the rules for round one. I will ask you a question, and you will hit your buzzer, and the first one to buzz in, I will call on you. If you hesitate even slightly in answering my question, I will interrupt you and ask you the same question 10 times until you get the answer. When you get the answer, I will slap on my podium and say, absolutely, and you will know you've done a good job. Is everybody ready?
Yep. Yes.
Let's go ahead and get started with round one. First question, what will the courts look at to determine if something is indeed work product? Professor Washington, very good. What's the answer?
Was it prepared in anticipation of litigation? And was it prepared by a party or by a party's representative?
That's absolutely correct, but what does anticipation of litigation even mean, Professor Washington?
Well, anticipation of litigation means the courts will look at two things. They're going to look at imminence. How likely is it that the litigation will occur? And they're going to look at motivation. Why was the document or the material prepared in the first place?
Absolutely. Very good, Professor Washington. So what she's saying is that work product can be created by someone other than the lawyer as long as they're a representative by or for the party and as long as it was prepared in anticipation of litigation. Very good, Professor Washington. Next question. I come in two different varieties. Ordinary or opinion? What am I? Professor Washington, very good. The answer, please.
I am work product.
Absolutely wrong. You are the two types of work product, Professor Washington. So it was a very good try, but try to be a little more precise next time. Okay. Next question, but very good either way. Next question. I deal with case strategy, and I go to the heart of what lawyers are thinking. I come in several formats like memos containing analysis of fact or law, evaluations of trial strategy, and analysis of witness credibility. Who am I? Very good, Dean Timmons. And the answer?
The answer is opinion work product.
Absolutely, very good. Now, incidentally, Dean Timmons, if that's opinion work product, what is ordinary work product?
Well, ordinary work product is everything else. It's like facts that don't have any sort of legal analysis or opinion.
Very good. Absolutely, Dean Timmons. Now, what's the significance of the two types? Dean Timmons, what's the significance? Professor Washington, I am not talking to you. Dean Timmons, do not drink that Coke in my class. The answer, please?
Well, purely opinion work product is usually never discoverable. And purely ordinary work product is usually always discoverable.
And what she means is, let's state this a little more precisely. What she means is that ordinary work product may be discoverable if it meets certain additional factors, which we'll get to later. So basically, when a court is looking at if something is discoverable or not, they first determine if it's ordinary or opinion work product, and then they must determine if it meets a few additional factors so that it may be otherwise discoverable. Dean Timmons, is there always a clear delineation between opinion work product and ordinary work product? Dean Timmons, sometime today, please.
No. On this side, we have purely opinion work product. And on this side, we have purely ordinary work product. Then there's all this stuff in the middle that's kind of opinion.
I think what Dean Timmons is trying to say is that Work product is evaluated on a continuum where ordinary work product is mostly fact, opinion is mostly analysis and lawyers' thoughts, and sometimes it can be arguable which is which type. I think that's what Dean Timmons is trying to say.
Yeah.
Let's move on to our fourth and final question. Well, final whole question. We'll have other parts of this question. The following factors must be present to use me. Material must be otherwise discoverable under Rule 26, meaning it must be relevant and non-privileged. There must be a substantial need for the material, and the other party cannot get the material or substantial equivalent without undue hardship. Who am I? Professor Curcio, it is about time we heard from you. The answer, please.
You are the exception that allows for the discovery of ordinary work products.
Absolutely, and incidentally, Professor Curcio, does extra expense constitute undue hardship?
Oh, I see what you're saying. No, not just an allegation of extra expense. That would not be enough. It's got to be impossible to get this. So there has to be a witness that is dead for you to obtain.
Absolutely. Now, although we don't want witnesses to die, she is absolutely right. It has to be a virtual impossibility. Now, what is substantial need, Professor Curcio?
Well, Professor Stevens, what do you think substantial?
Professor Curcio, we are not playing your little game that you started with me when I sat in on your class with Miss Person 2 weeks ago, where we went back and forth. As a matter of fact, it's clear that you may not understand this concept, so why don't I just answer this for you? Substantial need is that the material must be essential to proving the party's case. It's not enough that the material is merely useful or that it may merely be used to corroborate. It must be essential to proving the party's case. So thank you very much, Professor Curcio. One final question, because you are the Civil Pro guru. What is the policy behind all of this work product protection? Please tell our adoring fans.
Well, essentially, the idea is that litigation is a battle of the wits. And you all are not entitled to my wits.
Absolutely. Very good, Professor Curcio. That is absolutely right. Now, I'm sure that you've noticed that we have not been really taking score in this little game of ours. That's because I am the Cornel Stevens. This is my show, and I will allocate points however I see fit. And in that spirit, Dean Timmons, I do not agree with your ludicrous assertion that torts are better than contracts, so you have been eliminated. So I'm sure you have defamation or something to go teach, and as soon as Dean Timmons dismisses herself, we will go to commercial break, and we will be back with Professor Curcio and Professor Washington for our final round for the championship. Thank you.